Seems like we have everyone here on the Wooten case, Mr. Park and Mr. Koch. And Mr. Park, I believe you represent the appellant, is that correct?
Yes, sir.
And will you be reserving any time for a rebuttal?
I'd like to reserve 5 minutes.
I have made the notation, and I will try to advise you as close to the 15-minute mark as I can.
Thank you.
You may proceed.
May it please the court, Michael Park on behalf of the plaintiff in this case, Ms. Wooten. This is a case which really derives from a dissolution of marriage case wherein the final judgment, which was entered in 2004, required the former husband, who is now deceased, to maintain a life insurance policy in the amount with a death benefit of $350,000, with the former wife as the sole beneficiary of said policy under 61.08 sub 3 as security for life insurance and child support. Brief history of the case. The underlying facts in this case are really undisputed. The determination of the case was made at a summary judgment hearing where both sides had competing summary judgment motions, and both sides agreed that there were no issues of fact. Everything was an issue of law for the lower court to decide. Since this was summary judgment, it comes before this court really in a de novo capacity, as this court is sitting in the same position as a trial court would be, such that there really is no deference needed to be given to the trial court's determination, which frankly is pretty good because the summary judgment order granting and denying the competing summary judgment simply said one was granted, one was denied. No legal reasoning was actually even given by the court on that or even on rehearing. The technical defendant in the estate or technical defendant in the appeal is the estate of James N. Wooten, or Timothy L. Wooten, who was the deceased former husband. The final judgment, which is critical, was never appealed in 2004. So it was followed by both parties. The former husband had opportunities multiple times during the pendency or between the entry of the final judgment to his death, where the support obligations were changed multiple times. He never brought up the issue of the propriety of the life insurance requirement, nor did he seek to change that. So upon his death, the final judgment still required him to maintain a life insurance policy in the amount of $350,000 of a death benefit, with the former wife as the sole beneficiary of said policy.
Did the plan say there's a child support as well as alimony to secure?
Pardon?
Did the agreement and the final judgment say to secure the payment of alimony and child support?
Yes, it was for security for both, and it required he maintain the policy until he no longer was required to pay support in child support or alimony. And there's perhaps this is a good time to read the two critical paragraphs, because there are two paragraphs in the final judgment which set forth exactly what he was supposed to do. Final judgment paragraph 15 under life insurance says, quote, "The husband owns a life insurance policy on his life with a death benefit of $350,000. The husband shall, at his expense, continue to maintain this insurance policy on his life, having a death benefit payable to the wife upon the death of the husband in the amount of $350,000. The life insurance is security for the alimony and child support obligation. The obligation shall terminate automatically upon the last of both the child support and the permanent periodic alimony obligations." That's the first paragraph, which answers the question. It was to secure both the life insurance, the child support, and the alimony.
But what you're asking seems to be inconsistent with the plain language of this order, because if the alimony automatically terminates when the child's emancipated and when the husband dies, it's over. This order doesn't say that this life insurance is to support the wife after his death. There's case law very clear, sir, on point, that say if there's any intention to continue the life insurance proceeds for anything other than alimony for the life upon the death of the spouse for the benefit of the other spouse for other issues, that needs to be specifically articulated. That's not here.
With respect, I think we're mixing apples and oranges, because
How so?
Because if you read paragraph K, which says security for alimony and child support, which is the same part of the life insurance here. It says to provide security for alimony and child support, the husband shall maintain the existing life insurance policy on his life, having a death benefit of $350,000. And this is the critical part of this. The wife shall be named as sole beneficiary under the policy. So if this was a situation, and I know all the cases you're talking about.
Yeah, but who's the recipient of alimony? Her.
She is.
So making her the sole beneficiary is the proper thing to do.
No, sir. Because if you were talking about what is the intent of the trial court here, which I think is the valid question to ask. What is the intent of the trial court? Had the trial court intended this to only be for an arrearage, it should have said that. And
that's what the case law says. If it says it's for security, it's for arrearages, unless there's additional language. I know that you cited Sobelman, but Sobelman clearly says that the trial court can do what this judge did here, but they can also do extra. But if they do, they need to express it in the order.
With respect, the problem is if the court had intended this to only be for an arrearage, it would not have had the wife as the sole beneficiary of the policy. It would have said very simply, the wife shall be a beneficiary of the policy and shall be entitled to the proceeds up through the amount of the arrearage. The fact that it made her the sole beneficiary of the policy indicates that the court intended that she be granted the entire death benefit. Otherwise, you could have had the child be a beneficiary. You could have had his brother be a beneficiary. Could have had any other number of people be a beneficiary. And all the trial court would have had to have said would be the wife, former wife, shall be a beneficiary under the policy up to the amount of any arrearage. That
but
is
under O'Malley, we can't rewrite this, sir. O'Malley's very clear.
Absolutely. And
you're asking us to rewrite this order.
No, sir, I'm not. I'm asking you to enforce the clear terms of the order. To rewrite the order is what effectively this lower court did by not enforcing the terms of the final judgment. The terms, this is my question in my brief, which I think really needs to be answered. If the former husband died in compliance with this trial court's order, with this final judgment, who would be legally entitled to those proceeds? The only answer could be the former wife, because the policy, by the nature and the terms of the final judgment, was to be with her as the sole beneficiary of the death benefit. There would be no legal legal means by which she would be denied those proceeds. She'd get those by operation of law, by operation of that contract. The fact is undisputed. He did not follow the terms of the final judgment. The other side readily admits that. When he died, he did not have a life insurance policy in the amount of $350,000 with the wife as a sole beneficiary.
I have a question. Does the record reflect when he stopped paying the premium on the policy?
From what I understand, the record was, and I think this is even in their brief, that from 2004 through 2017, he had a policy in the amount of $350,000. And I think they stated that for various reasons with the company that was being phased out. However, I think it's critically important.
What do you mean was being phased out?
Pardon?
Explain what you just said.
From what I understand, and Mr. Koch can maybe add more light to this, but what I understand was because of his age and whatever else, that they were decreasing the benefit over
it was a company policy, company benefit. Yes. They were paying the premium. The agreement, but the order from the judge and the final dissolution doesn't affect what the company did or didn't do.
No,
there's no backup plan provided. If the company stops paying the premium, he was required to then singularly go get a replacement policy. That wasn't a factor in this case or this appeal.
No,
and that could have been. That could have been provided. So he dies with no insurance policy through no fault of his own. He didn't cancel it. The company stopped paying the premium for whatever reason. It was phased out, however you explained it.
Right.
So there's no wrongdoing on his part. There's no enforcement in his lifetime to make him get another policy.
Well, we didn't know that he was being...
Well, yeah, obviously you didn't know because no one volunteers information like that.
Sure. But I think what's also critical is there were other life insurance policies that he had in excess of the cumulative was in excess of $350,000. So it's not as if he didn't have other life insurance. He just didn't maintain the policy as he was required to.
So the obligation for alimony still was in existence when he passed away, but the obligation for the child support had technically terminated. Is that correct?
That is correct.
The alimony, there was a claim filed in the estate by your client, and then I understand that the pro rata amount was paid. Do I understand the record correctly?
Yes, sir.
Okay.
So when he died, he had paid the alimony up through his death, and obviously there was a pro rata amount for the month when he died, and he hadn't paid it, so the estate did pay that. And by stipulation, the estate held back $370,000 of the estate proceeds. We didn't go after any of the other beneficiaries of these policies. We didn't go after the insurance companies or bring them in because we were trying to limit, the litigation here. And by stipulation, the estate held $370,000, which would effectively be the $350,000.
What was the age of the particular parties? The former husband and wife.
I do not have that in front of me, Judge.
Okay. Can we argue they're in their 70s, possibly older?
I don't think they're that old.
I think they were in their 60s, if I recall.
60s.
The final judgment, I think, was Judge Lay, right? L-E-Y wrote, and I think it may have had the ages on the front page, but I don't remember. I see so many of these, just like you gentlemen do. Sometimes they kind of blur.
Yes, sir. My point back to Judge Sleet's question was, I think that by not enforcing the terms of this, once again, the question I posed, I think, is the question in this case. If he complied with the final judgment, the former wife would be entitled legally to $350,000 from the death benefit of that policy as the sole beneficiary. And by not enforcing that, due to his own decision either not to get a substitute policy or inform anybody of that, he died in basically in violation of the court order. Why should we reward that by taking the benefit that my client was entitled to now basically say she gets nothing? And so the fact of the matter is, all of the arguments that the other side is making in the case below and on appeal really are attempting to attack the terms of the judgment by saying there wasn't appropriate findings for purposes of whether it was dire financial straits, which is what Judge Sleet was talking about. Well, if you're going to have this, you need to tell us what it is. We got to look at the clear terms of the language of the final judgment and not modify it. And by not enforcing it, we are essentially modifying what would have happened by
Check your mic. We have some
You're
static
starting to come
issues.
out like a robot. I don't know if it's us or you.
Yeah, Mr. Park, there's some sound issues. We can
Okay,
hear
hold
you.
on. You're coming in like a robot, I think they call
Got
it.
a loose connection maybe, or a wire fell out.
Sir, I'm on a wired connection. Can you not hear me?
Yes, sir, but it's got like an electronic tone to it, I think we're cleared up now. Say something, please, if you would.
Yes, sir. Can you hear me
You're
now?
clear.
Yeah,
That's a
right.
bell now. Thank you.
Everything's back.
Mr. Park, I appreciate your argument. I just want to be able to reconcile your argument with the fact in paragraph 15 and repeatedly through the order or the judgment that keeping life insurance is an obligation of his, and the obligation terminates automatically at his death.
Right.
So the obligation to keep the insurance for her terminates.
After
There's
his
no
death,
other language. I get what you're saying, but you would agree with me that final judgments of dissolution of marriage, particularly alimony provisions, and within these final judgments have to be very clear, and the court has to make specific findings, as 6108 says. But the court doesn't say anything about death benefit at all.
yes, sir, it does. It says in
No,
paragraph.
it just says sole beneficiary. It didn't say the wife's entitled to a death benefit
Yes, sir, it does.
after his death.
It says the husband shall, at his expense, paragraph 15, continue to maintain this insurance policy on his life, having a death benefit.
Yeah, but that's life insurance has a death benefit. That's what life insurance is for. That's
Yes,
not
sir.
the judge saying that.
That is the judge's language.
Yeah, but what else is life insurance for?
But here is with respect, here's the problem with that argument, Judge Sleet. If you're saying that since alimony terminates upon the death of the party, that all of a sudden the life insurance obligation to maintain it terminates, I would agree with that. However, that doesn't mean that the death benefit doesn't inure to the benefit of the former wife. The whole reason we have life insurance is somebody dies and the death benefit gets paid. So there's an alimony obligation up through the date of this man's death. If what you're saying is he no longer has an obligation to carry life insurance, ergo she has no right to those proceeds, you would create a nullity of 6108. And we look in Sobelman, we look at the progeny of Sobelman, and what the court has said, and this court in Sobelman 1, as I've stated in the brief, basically took that exact position, which was, look, life insurance is only to secure arrearages. And if there's no arrearages, there's no life insurance. And the Supreme Court expressly rejected that conclusion and overturned this court and said, no, there are circumstances in which the entire death benefit gets paid, regardless of whether or not there's any arrearage. And I know Judge Altenburn, in multiple opinions, has taken issue with what you're talking about, which is, hey, if you're going to be allowed to have death benefits payable in their totality to these parties, we would like a little bit more in these orders. But the problem is you're going back now and attempting to rehabilitate the final judgment and insert into the final judgment language that's not there. What we have is a death benefit payable to the wife as a sole beneficiary under it. And this is very different from a situation where you simply say, well, as security for alimony, the former husband has to have a life insurance policy. We have a sum certain, we have a specific beneficiary who's entitled to all of those proceeds, such that there is no question that anybody else should be entitled to these things. And once again, if he complied with the final judgment, she would be entitled to 100% of these proceeds. And by not giving those to her, we are changing the terms of the final judgment, which was not appealed.
I need to tell you, we're past 15, but I want to give you a couple of minutes for when you were a minute and a half while you were robotic to get you there. So now we are officially at the 15 with that correction.
Okay, then I will I'll reserve the rest of my time. Thank you.
Thank you. Counsel, is it pronounced Mr. Koch or Mr. Koch?
It's Kai Koch, Judge. How are you this morning?
Thank you, sir. It's been a while, but I want to make sure I got it right.
Good morning. Good morning, Mr. Park.
Good morning.
You may begin.
Thank you. Ms. Wooten is requesting this court to utilize an extremely strained, and I give them the benefit of the doubt in using that term, interpretation of what this final judgment says. The final judgment was entered in 2004 by Judge Lay. It's 35 pages in length. We are here dealing with two specific paragraphs from that final judgment. Paragraph K, which Mr. Park referenced, and paragraph 15, found at the record at pages 190 and 194. The last two sentences of each of those paragraphs, which relate to life insurance, resolve this issue, I suggest to you, unambiguously. Those two sentences read, this life insurance is security for the alimony and child support obligation. This obligation shall terminate automatically upon the termination of the last of both the child support and permanent periodic alimony obligations. That's from paragraph K in the court's findings. I'm sorry, that's from paragraph 15 of the court's findings. Paragraph K is from the court's ruling, entitled Security for Alimony and Child Support. The last two sentences, again, very similarly read, the husband shall maintain the life insurance policy or a comparable policy for so long as he is obligated to pay either child support or alimony. When the husband is no longer obligated to pay either child support or alimony, the husband's obligation to maintain this insurance shall automatically cease and terminate. So throughout the language in both of those paragraphs, the trial court told us that the life insurance is being employed as number one, security, that number two, the life insurance will terminate at the termination of alimony and child support, and number three, that it is an automatic termination.
Mr. Cox, let me ask you a question.
Yes, sir.
Mr. Park raised, the wife is the sole beneficiary. The order does not indicate whether there could be a co-beneficiary or multiple beneficiaries. So I think it's undisputed that at your client's death, that policy was valid and she was still the sole beneficiary. Is that correct?
I think in answering your question, yes, she was intended to be the sole beneficiary from start to finish.
Okay.
Yeah.
So upon his
there
death,
was no policy. I'm sorry.
There's a delay with your voice. I see your mouth moving and then the sound comes, but I'm sorry to interrupt you. Go ahead. Go ahead with your thought.
There was no life insurance in effect at my client's death, for which Ms. Wooten was the beneficiary. Did I answer your question?
I think so. Now, do you read Sobelman to hold that a trial judge can do what Judge Lay did in this particular case, but if the life insurance is intended to support the wife beyond the death of the payor, that the order should set forth that? Is that correct?
Absolutely correct. Yes, sir. Justice Kogan very clearly stated in Sobelman that life insurance may be payable in appropriate or special circumstances, as this court has later addressed in Massam, I think it's M-A-S-S-A-M, and Biscaglia, written by Judge Valenti and Judge Casanueva, that yes, in special circumstances, it is available for a trial court as an integral part of equitable distribution and support to order to families in dire circumstances or in particular circumstances and issues of need that the death benefit be paid in spite of alimony and child support.
Well, it's basically, Judge Sleet, I didn't want to interrupt you. I had a question, but I can wait.
No, I'm fine. Thank you.
I mean, to work this into the way the appellant's contending, it seems to me this would force a savings component into an alimony obligation that doesn't exist in this case. She would get, I'm going to use the term windfall loosely, but it's more than security when you get the proceeds against an estate from a person who was current in his obligation. And I don't see how the alimony would apply to the death benefit, even though she's a sole beneficiary, so long as he wasn't current. But he could have canceled that policy at any time to differentiate the child support and the alimony amounts. I just don't, I'm having trouble following his argument. I'm not saying it's a slam dunk for you, but I'm having trouble following his argument. Maybe you could help me if I'm missing something.
Far be it from me to
that's the Kai Kutch we know and love.
to enhance Mr. Park's argument, but
well, I'll let him do it. But I'm just a little bit concerned we would be extending something on life insurance I don't think the law currently recognizes.
And I completely agree, Judge. You use the term windfall loosely. I use it tightly. I suggest to you if y'all were to overrule this order and Ms. Wooten received $350,000 of this death benefit, that would purely be a windfall to her. In a circumstance where, by the way, the stipulated facts are my client was on time, completely discharged his child support obligation a decade prior to his death. My client was never in arrearage in alimony, was paid up to date at the time of his death, with the exception of the pro rata payments for the month of June in 1999 when he died. And that was immediately paid by the estate. This is not a special circumstance case. This is not an appropriate circumstance case as addressed in Sobelman, Massam, and Biscaglia. Ms. Wooten received north of $2 million equitable distribution, $19,000 a month in child support, which over the term that it was paid was north of $2 million as well, almost $2,000 a month in child support. All of those were paid in full. And had Judge Lay intended for this death benefit to have been paid to Ms. Wooten over and above those amounts, Sobelman existed as of that time, and it was available to her to say, I find that Ms. Wooten could be in dire financial straits, and therefore this death benefit is payable to her irrespective of alimony and child support being paid. That wasn't said. Y'all tell trial judges every single day that you must articulate your reasons for doing what you do. It didn't happen in this case. And the reason it didn't happen was it wasn't pled. There were no facts to support it. This lady, Ms. Wooten, came out of this well-funded, and there is no special circumstance or appropriate circumstance contemplated under the law for this to be payable to Ms. Wooten. I do wish to address briefly, I think Judge Sleet addressed the question of sole beneficiary. Just because Ms. Wooten is listed as a sole beneficiary does not mean that this policy should survive and be paid to her upon Mr. Wooten's death, especially since she's paid out in child support and alimony. Sole beneficiary, in my mind, relates to the amount of the policy securing child support and alimony. If Judge Lay were to have said, Ms. Wooten is a beneficiary or shall be a beneficiary, that could invite a dilution of beneficiaries and ace Ms. Wooten out of the security that she was intended to receive. We don't contest that. We think she certainly had the ability to do this. And even if we didn't think that, we're 17 years hence from this final judgment and have no ability to contest its language. But the language is very clear, and that is upon Tim Wooten's death, alimony died, his child support obligation died, and this final judgment was completely satisfied.
I think one of Mr. Park's arguments relates to the use of the word sole beneficiary, that ramps us into a different category, when it seems to me that the judge used that term sole beneficiary to avoid this gentleman putting another beneficiary on there, that she would get all these proceeds. If you pay $19,000 a month in alimony or child support, some ungodly amount, you multiply that by a couple of years and you've easily got $350,000 in arrearages that would need to be secured. So if she wasn't a sole beneficiary, that would be a problem that this judgment stops. But it doesn't go forward to say once you die, she's a sole beneficiary of that entire policy. If you fail to maintain the premium, you're responsible, you're insuring this amount. I don't read it the way Mr. Park's arguing, but maybe he's heard my question, which really isn't a question, it's a comment. He can reply to that when he gets a chance.
I will yield to Mr. Park.
Well, don't go just yet. I'd like to explore part of these with you, if I might, counsel.
Yes, sir. Sorry.
That's all right. No, we're kind of disjointed doing this electronically. As I look at the final judgment, specifically those two relevant paragraphs in the factual finding 15 and in the order and judge section, capital letter K, in terms of our construct, that is, as we analyze them, do we analyze them as a totality, or do we only analyze subparagraph K as the ordered and adjudged part?
I haven't thought about that, but I think that the court reviewing this de novo would look at them in totality.
For example, in a contract, we'd read everything in pari materia, and I'm wondering if that's the same rule we'll do to this final judgment.
I believe it is.
Okay. So if I can direct your attention to paragraph K in the ordered and adjudged section first, it says the husband shall maintain the life insurance policy. I'm going to delete the unnecessary language, for so long as he is obligated to pay. So obviously there's a breach of the order here because he didn't do that. but in terms of interpretive stuff, when the husband is no longer obligated to pay child support or alimony, child support, all the children have reached majority. Interestingly, alimony would cease upon her death or his death. Is that right?
Yes, sir. And may I comment briefly on that?
Please.
So alimony, under the specific terms of this final judgment, and as we know from the law, terminates upon death, or remarriage, automatically. Death of Mr. Wooten, death of Ms. Wooten, remarriage of Ms. Wooten. I submit to you that this question being submitted by Ms. Wooten would never see the light of day had this alimony been terminated by her remarriage. It would be preposterous for her to suggest that my remarriage has terminated alimony, but Mr. Wooten should continue to pay this life insurance that is meant as security for alimony. I submit to you that it would be preposterous for her estate to argue, if alimony were terminated by her death, that the life insurance obligation should survive her death and be payable to her estate. That is certainly not contemplated by the law or this final judgment. And why should it be any different under the circumstances that we find ourselves in here today?
Would it also be fair to conclude that either as a matter of fact or implication of law, that the trial court judge was well aware of the law of when alimony obligations cease?
Judge, the answer to that is Judge Lay worked for me and was my partner and practiced divorce law for years before she became a judge. She sat on the divorce bench for years and was certainly well seasoned at it.
So obviously, as a matter of fact and as a matter of implication by law, the trial court would be aware upon the events that would trigger the expiration of an obligation to pay alimony.
Yes, sir.
Because that language, when the husband is no longer obligated to pay alimony, could be triggered by A, his death or her death or remarriage.
Yes, sir.
So the only thing further in the last line, it says, then the obligation to pay the insurance shall automatically cease. So it is seemed that the trial judge was attempting to make the obligation to maintain coterminous with the legal duty to pay alimony.
That's my read of it. Yes, sir.
I'm just trying to make sure if that's a construct. At least it is arguably a construct, and Mr. Park, I'm sure, will tell me why it's not the appropriate construct. I'm just trying to work my way through the language that the trial judge has left us. Thank you. I didn't mean to take as much of your time as I have, but you still have about 5 minutes remaining.
I'm done, Judge.
Okay. Well, then I didn't really overimpose upon your time then, did I?
No, sir.
Okay. All right. Thank you, sir. And we'll return to Mr. Park. And you have your 5 minutes, sir.
Thank you. Let me discuss that last question, line of questioning, Judge Casanueva, because I think we're missing something very important here. The fact that this obligation was to terminate upon his death, her death, or her remarriage does not basically turn this into an illusory requirement.
Well, there's two obligations that this final judgment has created. One, the obligation to pay alimony, and two, the obligation to secure the ongoing, or at least say the payment of alimony. And the question that remains is, which one, if any, can be extended? And obviously it'd have to be the insurance. Because by law, the obligation to pay ceases at her death or his death or remarriage. And we know he died.
Correct.
So then the question is, does a second obligation to secure and to pay the benefit continue on, because that was the intent of the trial judge?
Those are two very different things.
That's why I'm going through the whole thing as how do we interpret this?
The requirement to maintain the insurance policy terminates on his death. I wholeheartedly agree with that. But that's a very different issue than whether or not the
insurance was required to pay the death benefit to her. Obviously, if he dies, he's no longer required to pay alimony, but the final judgment still required him to pay, or the policy to pay the death benefit to her in the amount of $350,000, which was stated clearly in the final judgment, and she was the sole beneficiary of it. So the fact is that the final judgment accurately states that he no longer has the requirement to maintain the policy or pay for that policy after his death. But it doesn't say that he no longer has the requirement, or the insurance company no longer has the requirement to pay the death benefit to her. Because if that were true, then this whole thing is illusory. He paid all these premiums for all these years for an illusion, because the death benefit would have never gone to her. And it basically would have been, if that were true, then even the payment of the arrearage would terminate, because if she's not entitled to any of those proceeds from the insurance policy, she's not entitled to any of it, regardless of whether there was an arrearage or not. That is not what this final judgment says. And we're effectively going back and attempting to retry or appeal the language of the final judgment under, well, did the court put the right stuff in? Did the court have enough findings in here? Those were all things that if the deceased decided those were issues in the final judgment, he had an obligation to bring those up within the time period for the appeal. And I've cited those cases in my brief where he didn't do it. And I also want to make the point that even if this was an erroneous finding, that even if you think this is post-mortem alimony, the case law is very clear. He had to appeal that within the time period. And if he didn't, even if it would have been erroneous, and if back at that time you would have overturned it because the factual findings weren't there, or you didn't think there's special circumstances or whatever else, the final judgment terms still stand, and they have to be enforced. And if you don't enforce the clear terms of this, which was she's entitled to the death benefit as the sole beneficiary as of the date he died, we are effectively rewriting the final judgment and the clear terms that are required to be complied with. There is no dispute that the deceased did not comply with the terms of the final judgment. Had he complied, she'd be entitled to these death benefits. She isn't receiving those now, and legally she otherwise would have been. To get back to the other issues which were addressed, this whole idea of security. First of all, 6108 sub 3, it talks about security. And that was the whole point of Sobelman 1 and Sobelman 2 that this court decided years ago, where this court interpreted that saying, look, security is to secure arrearage. And we're not going to take it beyond that because we think that's post-mortem alimony. The Supreme Court said, no, that is not how that language is to be interpreted. And there are cases afterwards which say no. And in fact, the Aldridge case, which is one I cited in my brief, that one was the one that talked about whether or not, if it's a final judgment and it wasn't appealed, it stays. And then the Kearley case, which I cited as well, says, however, the final judgment merely states that the former husband or the husband shall provide life insurance in an amount. It can't be ascertained whether the entire policy proceeds will be paid over, as security for his alimony obligations. It cannot be ascertained whether the whole amount or part of the amount were to be given to her for the arrearage. Either arrangement may be appropriate. Either arrangement. So this idea that somehow—
I need to ask you to sum up because we're past 5.
Yes, sir. The idea that because it says it's for security means that it can't go for anything other than an arrearage is not borne out by the case law. And it's not borne out by this court's case, which clearly was this court's case in 1999. And unless you have any other questions, I'm out of time. Thank you.
Thank you. We could have hoped that Judge Altenburn's concurrences 20 years apart might have received a response from another source, but unfortunately they did not. So we will do our best with this one. Thank you both, and please stay well.